this is just a hugely important case and a hugely complicated case. It is not an exaggeration to say that just about every issue we've talked about crashes into each other. The sides crash into each other on this case, going all the way back to the Federalists and the Anti-Federalists. It's also an enormously important turning point for an understanding of the Reconstruction Amendments, and I already gave away the punchline last time. The Supreme Court is going to use this case to strike down an interpretation of the 14th Amendment in particular, but I also talked about the 13th, that would have meant that Congress would have broad sweeping powers to reshape economic affairs and political relations in the way that, in fact, Congress did exercise in the 1960s, 7 years later. 3 years later. 7 years later. 60 plus 30. 90 years later. I can do this. The problem is that in the middle of the analysis of the Slaughterhouse cases, there's one piece that's really confusing. And students always go crazy trying to figure this out. And so I'm going to change the way I teach this case. Usually I just go through it in the order in which the arguments are presented. I'm going to do it differently. I'm going to introduce you to the tricky part and lay it out without context, so that then when it reappears, my hope is that when it reappears, it'll make sense to you. Fair enough? All right, so one of the questions in this case is, well, the key question in this case is, what is the meaning and the scope of the Privileges and Immunities Clause of the 14th Amendment? One of the questions, which I alluded to last time, is, should we understand the Privileges and Immunities Clause of the 14th Amendment in the same way as, or a different way than, we understand the Privileges and Immunities Clause of Article 4? Does the 1787 constitutional understanding dictate our 1868 constitutional understanding, or vice versa? We talked about these possibilities last time. There's different ways you can work with the fact that this same phrase is used at radically different points in history. The argument of the majority, Miller writes the opinion, is going to be, we must read the Privileges and Immunities Clause of the 14th Amendment to mean the same thing that the Privileges and Immunities Clause of Article 4 meant. That's the first key point. And if you don't, if as we're going through, you don't catch that, you'll be very lost. So that's the first key analytical moment I want to point to here. Second, okay, great, what does that mean? According to Miller, just without without arguing whether he's right or not, what's Miller's argument about what is the meaning? What is the meaning of the Privileges and Immunities Clause in Article 4? And here's where everyone gets confused. So I'm going to say this really simply, I hope. In Article 4, the Constitution says no state shall deny the privileges and immunities of citizenship to citizens of another state. That is understood to mean, and we'll get to the detailed argument, but I'm just going to give you the rule. Rights come from states. Remember, the Bill of Rights doesn't apply to the states, right? So rights come from states. There are two classes of rights that come from states. Some are fundamental, some are not. If, and only if, we are talking about a fundamental right, then a state is not permitted to grant that right to its own citizens to a greater degree than it grants the same right to citizens of other states. It's an equal treatment principle. The state may not preferentially protect the rights of its own citizens. That does not mean that the US Constitution requires states to give anybody any particular rights at all. The Bill of Rights does not apply to the states. There are no constitutional rights, except for Article 1, Section 10, the Contracts Clause, the Ex Post Facto Clause, except for that very, very, very limited protection of economic property rights. There are no constitutional rights that apply to the states prior to the 14th Amendment. It's a really basic principle, but people keep slipping on it. Every time you say that, everybody nods, and then you discuss something like Article 4, and they're confused again. The Constitution, as of 1787, does not require any state to accept any particular right. Free speech, the right against religious establishments. Pick it, doesn't any. Okay? But if the right in question is classed as fundamental. And if, two conditionals, if the right is fundamental and the state protects that right with respect to its own citizens, it must protect the same right for citizens of other states. Simple example, if there is a fundamental right to make contracts, business contracts, just ordinary contracts, just to engage in business. If there's a fundamental right to make contracts under the laws of the state, then if I'm from the next state over and I come into your state, I have to be allowed to make contracts in the same way. Get it? Now notice what that means. If, let's pick a state. This is easier, I think, if I just name states, right, and do it that way. So we're talking about Virginia and Pennsylvania. If Virginia has a law of contracts, which it did, it has to allow people from Pennsylvania to make contracts in the same way that people from Virginia make contracts. That does not mean, obviously, that Virginia has to allow everybody to make contracts. Why not? Slavery. If there were any rights at all that states were required to respect, there couldn't be slavery. It's impossible. Slavery denies all rights, all at once. So if the law in Virginia is that white people over the age of 45 and nobody else may make contracts, then white people in Pennsylvania over the age of 45 may make contracts. But that's all Article 4 meant. It was an equal treatment provision. And it's triggered if the right in question is fundamental, and if the state, both have to be satisfied, and if the state chooses to protect that right for its own citizens. Does everybody get that? I'm hoping that when I lay it out this way, it sounds very simple. In the past, I've tried to teach it as it comes up in the case discussion, and it's just a constant source of confusion. So, again, spoiler alert, Miller is going to argue that the Privileges and Immunities Clause of the 14th Amendment is likewise nothing more than an equal treatment provision. It does not require states to protect any particular rights at all. But if they protect them, and if those rights are fundamental, then, and now I'm going to leave kind of an ellipsis, something akin to Article 4's equal treatment requirement with respect to people from other states. Good? All right, I want to get that out of the way first just because it's the hardest part. I don't think it's in one way it's a terribly important part. That's the point at which Miller says the 14th Amendment Privileges and Immunities Clause does not create any substantive rights states are bound to respect. That's obviously a huge deal. That's the point at which the court turns away the idea of the 14th Amendment as an instrument for grand social change, right? Because states don't have to give anybody any rights in particular. So really very little has changed. So it's critical in that sense. But I think that to understand Slaughterhouse, we have to go back a little bit and set up the context. And we can go all the way back to the Federalists and Anti-Federalists. What did Kramnik say was the easy but incomplete description of those two sides? The easy and not false but incomplete description was that the Federalists were modernizers, liberals, commercial interests, pro-economic development, all like that, right? And the Anti-Federalists were nostalgic Republicans, largely agrarian, and in that sense conservative. Going through the Jacksonian era, that divide becomes more pronounced as the political economy develops. From the Jacksonian era, Jacksonian Democrats, what do they hate? I mean, yes, slavery was always a huge issue, but it wasn't the only issue. What did Jacksonian Democrats say? Corporations, railroads, banks, East Coast banking elites, like that, right? The Goldman Sachs of its day was, actually, I don't know, Bank of London probably, Bank of England. There was a lot of lending from London to the United States all through the 19th century, right? And the Whigs and then the Republicans were pro-business, pro-corporation, pro-development, build the transcontinental railroad, modernity, industrialization. So that conflict over political economy and all the cultural baggage that goes with it ran all the way through the 19th century and was one of the defining conflicts of politics of that era and of constitutional politics of that era. And one phrase that shows up over and over on the part of Jacksonian Democrats who hate these newfangled modernity with its financial systems and its stock markets and its corporations and its railroads was class legislation. Remember that phrase has shown up a few times. Class legislation means laws that benefit one economic group over another. Example, you set up laws that give corporations special privileges. That means corporate shareholders have advantages over any other economic actor. And they do. They're not liable for debts. They're not liable for damages. The thing never dies. You never have to deal with inheritance taxes. To this day, by the way, if you buy stock, when you die and your kid inherits that stock, all taxes for the increase in value during the period of your lifetime are wiped away. The clock starts over. Right? You don't pay tax. When you buy stock, you only pay taxes on the profits you make when you sell it. It's called capital gains. Everybody understands this? I know this is basic, but bear with me. Because if you don't happen to get this, this would be a useful tidbit to carry on with. When you buy stock, you don't pay taxes on the money you use to buy the stock. You only pay taxes on the profits you make when you sell it. That's why if you lose money on stocks, you lower your tax bill, which is why you can do all kinds of fancy things with your tax bill by deliberately losing money in one place and making money in another and moving things around and all like that, or timing when you sell things. If you are wealthy enough or fortunate enough to be able to buy stock and keep it and let your kids inherit it, let's say you bought it when you were 30 and you lived to a nice, decent old age of 90, the capital gains of those 60 years are not taxed at all. They drop to zero. So the laws creating corporations and the tax code that affect corporations clearly give enormous advantages. You can also reside in wherever you want without having to have a house there, right? You and I have to actually live somewhere and prove it. Corporation just registers. Bahamas, Delaware, South Dakota, whatever. And so on and so on and so on. So laws establishing, I'm emphasizing this point because during the Jacksonian era, this was why. This was the driving force of the argument that these new business corporations that are springing up all over the place, initially to build railroads and telegraphs, are a problem. And it was because they were the classic example of class legislation. Using the law to create economic advantages for one set of competitors over another. But that wasn't a constitutional issue exactly. Nothing in the Constitution says states may not have class legislation. Bill of Rights doesn't apply to the states. Again, it's so hard to keep that in your head. But after the 14th Amendment, we have the Privileges and Immunities Clause. Now there's a new argument. We talked about the 13th, 14th, or 15th Amendment in terms of the end of the Civil War and race relations and all of that. And that is the context in which they were adopted. But very quickly, after the 14th Amendment was in place, people began to use it as an argument for a newly popular economic theory that got started around the 1850s called laissez-faire. Government should not be involved in the economy. I'm not going to go through it. It goes back to Scottish common sense philosophy. It was originally a religious doctrine that said God intends certain natural balances in the market, and that to interfere with them is a violation of a divine order. It lost its religious elements around the 1820s with the New Presbyterians, and so on. If you're interested in the intellectual history of laissez-faire economics, I'm happy to sit down with you. But even for me, that's too far a digression. But in the 1870s, this is a very popular idea among some people, particularly pro-business Republicans. Pro-business Northern Republicans, right, are economically modernizers, and they want untethered, unfettered markets to go and do their magic. And so they use the 14th Amendment to argue, and that's what this case is about, that the Privileges and Immunities Clause means no more class legislation. That's the question in this case. Does the 14th Amendment mean that states may no longer enact what courts find to be class legislation? Specifically, the case about a monopoly. Crescent City Slaughtering was given a monopoly on conducting slaughtering operations in the city of New Orleans. All slaughtering operations had to take place at their facility. There were all kinds of specific health and safety requirements. They were required to make their facility open to anybody on equal terms. They were, in this sense, a common carrier, if you remember that phrase from our earlier discussions. Right, this is the old model of corporations. You give them a special privilege, but they have special duties. You give them the monopoly. Only they can operate a slaughterhouse in New Orleans, but they have to take all comers on an equal basis, charging equal fees and so on. And the rules included that the thing had to be adequate to service all the businesses and so on. There were lots and lots of rules. But the one that the case is about is the monopoly. Does the 14th, and here's where we get to this remarkable question. Does the 14th Amendment mean no more monopolies? And if the answer had been yes, that basically would have meant the end of the modern business corporation. Or at least it would have pointed in that direction. So the argument is a profound one. The argument is that now that we have rights, let me just present the argument in the words of the argument, rather than try to analyze it. Here's how it would sound, and you'll see Field make this argument. When we adopted the 14th Amendment, remember in the American Revolution, we always talked about the rights of Englishmen? Well, when we adopted the 14th Amendment, says Field, the dissenter in this case, we invented something called the rights of Americans. Never had them before, because none of the rights in the Constitution ever applied to the states, but now they do. Everyone, by virtue of being American, is entitled to certain, watch this phrase, fundamental rights. Now you see how important that previous discussion is going to turn out to be. Everyone who's American is entitled to certain fundamental rights. States may not interfere with those rights. What do those rights include? Common law property rights, vested property rights, all the way back to the Federalists concerned with the protection of property against politics. And in order to protect those rights, we call on the courts to end the practice of class legislation. That's the context of this case. The number of things that are involved here. Notice, if you accept Field's argument, the argument that as Americans we all have certain rights, that states are bound to respect because of the 14th Amendment, if you accept that argument, look what that does to the black codes, and later to Jim Crow, and to segregation. You wouldn't need the 1875 Civil Rights Act if in 1873 the Supreme Court had said all Americans are entitled to engage in economic activities on the same basis. So the radicalism here, if it had gone the other way, it's being driven by a desire to impose a Jacksonian sense of laissez-faire economics, or if that's too broad, a Jacksonian sense that class legislation is improper and wrong and just bad, and for moral reasons, legal reasons, just, right? Is an invalid form of legislation. That would be combined with empowering Congress under 14.5 to engage in precisely the kind of sweeping remedial legislation that Congress was talking about during this decade. So you can see why the stakes are incredibly high in this case in 1873. Last comment before I dig in, 1873, this is less than 5 years after the adoption of the 14th Amendment. I mention that because as we go through the arguments, you'll hear repeated references. Well, back when they were considering the 14th Amendment, we think they must have been talking about, it's 5 years ago. You could ask them. There's a very good reason nobody does. Nobody wants to actually know what they were arguing about. Both sides want to use this case to present a constitutional theory. Let us dig in and see what it is. So here's Miller. And he starts with a traditional analysis that states have police powers. And this is going to be such a critical concept going forward that let me read you a little bit about what he says about it. The power here exercised by the legislature of Louisiana is in its essential nature one which has been up to the present period always conceded to belong to the states. However, it may now be questioned in some of its details. Right? Police powers, that's the core state function. States, there are no general federal police powers. That's what states do. States look out after the health, safety, welfare, and morals of the people. This power is and must be from its very nature incapable of any very, very exact definition. Upon it depends the security of social order, the life and health of the citizens. It extends, and he's now quoting Lemuel Shaw, a Massachusetts judge, writing considerably earlier. It's about 30 years earlier. Says another eminent judge, to the protection of the lives, limbs, health, comfort, and quiet of all persons, and the protection of all property within the state. In other words, all of civil and criminal law, social and political and economic order, just law, just law. Persons and property are subjected to all kinds of restraints and burdens in order to secure the general comfort, health, and prosperity of the state. Right? This newfangled laissez-faire idea is nonsense. Police powers has always meant that states can regulate social and economic conduct as they see fit to protect health, safety, welfare, and morals. That's what states are for. That's the common law model. The common law model, remember, was a very highly regulated society, regulated at a local level, with extremely intrusive regulatory powers granted to the government. That's police powers. Anything that serves to protect health, safety, welfare, and morals, anything you can fit into that category is a legitimate exercise of state power. So this is an absolute rejection of these new emergent economic theories as a legal or constitutional concept, whether it's good or bad economics, who cares? There's no such notion in our legal tradition, says Miller. Of the perfect right of the legislator to do this, no question ever was, or upon acknowledged general principles ever can be made so far as natural persons are concerned. Why natural persons? Because corporations are different. All right, that's the setup. He's actually gone through, in the original opinion, a long discussion of English common law history that ends with this. And Field also goes through a long discussion of English common law history. And I have mercifully spared you both of them. But one of the many interesting things about this case is that the structure of the two opinions are identical. Each of the justices begins with a long discussion of English common law history, and each then says the following. As we turn to the US Constitution and the 14th Amendment, right? So Miller has laid down his background. I don't buy this new theory. There's always been police powers. Police powers are ancient and traditional. We understand this. No one's ever doubted them before. So if I'm going to grant your argument, he's saying, it'll be a radical new argument. He's taking the conservative position. The people challenging the monopoly are taking a radical position, a conceptually new position we've never heard of before, he says. And he says, and Field is going to say almost the same thing, this is the most important question ever. We do not conceal from ourselves the great responsibility which this duty devolves upon us. No question so far-reaching and pervading in their consequences, so profoundly interesting to the people of this country, and so important in their bearing upon the relation of the United States and of the several states to each other, and to the citizens of the states and of the United States, have been before this court during the official life of any of its present members. Why is this such an enormous question? Because if the 14th Amendment means states have to change the way they do everything, states have to change their entire system of economic regulations, or at least they can be called into question. If the 14th Amendment means states are now limited in the way that the federal government has been limited before, and the 14th Amendment means Congress and the federal courts, notice this is happening in a court, have the power to intervene in states in that way, everything is different. Federalism is completely rewritten. The obligations of states to their citizens, completely rewritten. The rights and prerogatives that attach to Americans by virtue of the rights of Americans phrase I'm using. It's a brand new constitution if, says Miller, I rule in favor of the petitioners here. Well, to answer this question, is this what the 14th Amendment means? He says, we must first turn to its purposes. And this is where that irony of the fact that it's only 5 years earlier comes into play. The most cursory glance at these articles disclose a unity of purpose when taken in connection with the history of the times, which cannot fail to have an important bearing. That history is fresh from the memory of us all, and its leading features are free from doubt. Notice, by the way, this is not what we call originalism. Originalism is the theory that a court is bound by an historical understanding. This is merely being informed by historical understanding. But that's not the most interesting part here. The cutest part here is when he says it's free from doubt. If it's free from doubt, why is it a 5-4 decision? To this day, Supreme Court opinions are full of justices saying, it is obvious that. It is beyond the need for argumentation that. There is ample evidence to prove without any doubt that. And they say these things while they're writing 5-4 opinions. 4 of the members of their own court don't buy their argument, but it's obvious. Always watch out when a Supreme Court justice calls something obvious. That means it's wildly not obvious. So what was the context? Slavery and the black codes. I'm going to skip ahead a little bit, but if you look at pages 4 and 5, you'll see these long discussions about how after the Civil War, slavery was adopted. The southern states adopted the black codes to reintroduce slavery in all but name. So the 14th Amendment was adopted to undo the black codes. This is a history that we've discussed. And Miller goes through it in a perfectly straightforward and sensible way. There's also the issue of the right to vote. I'm now on page 6, paragraph 2, or page 3 of the notes, if you're following along. They were in all those states denied the right of suffrage. The laws were administered by the white man alone. The Negro, having by the 14th Amendment been declared to be a citizen of the United States, is thus made a voter in every state of the Union. I'm sorry, he's referring to the 15th Amendment. The 14th Amendment wasn't sufficient, he says, because even after the 14th Amendment, they were denied the right to vote, so we added the 15th Amendment. So we wouldn't have this situation of black people being ruled entirely by white people. In other words, these amendments were about race relations and racial equality. That's why they were adopted. And to understand the scope of these amendments, therefore, says Miller, we must limit them to the purposes for which they were adopted. We do not say that no one else but the Negro can share in this protection. Both the language and spirit of these articles, spirit of the Constitution, are to have their fair and just weight. But what we do say, what we wish to be understood, is that in any fair and just construction, it is necessary to look to the purposes which we have said was the pervading spirit of them all, the evil which they were designed to remedy, and the process of continued addition to the Constitution until that purpose was supposed to be accomplished, as far as constitutional law can accomplish it. All right, so we're going to assess the 14th Amendment in this economic context by asking what were its purposes, and do those purposes reach as far as banning the grant of monopolies or other forms of class legislation? All good? One of the many problems with wearing a mask is that I take my glasses off because otherwise they steam up when I'm lecturing, and that means I can't really see your facial expressions, not to mention that you're also wearing masks, so I can't really tell what the... You'll raise your hand if you have a question, right? All right, so what was the purpose? How do we understand the purposes of these amendments? Well, first of all, he says, everyone realizes the 14th Amendment overruled Dred Scott. The first observation we make on this clause is that it puts at rest both the questions which we've stated, skip that sentence, sorry. It declares that persons may be citizens of the United States without regard to their citizenship of a particular state. And it overturns the Dred Scott decision by making all persons born within the United States and subject to its jurisdiction citizens of the United States. Got it. 14th Amendment says anyone born in the United States is a citizen of the United States and of the state in which they reside. What it didn't overrule, though, says Miller, was Dred Scott's theory of dual citizenship. We're going to bring forward from Dred Scott this fundamental idea of dual citizenship, that being a citizen of a state and citizen of the United States mean different things, and that this has very specific consequences for the constitutional demands that are placed on each. Not only may a man be a citizen of the United States without being a citizen of a state, but an important element is necessary to convert the former into the latter. He must reside within the state. Right? If you're born in the U.S., you're a U.S. citizen. That by itself doesn't make you a citizen of any particular state. To claim state citizenship, you have to reside there. There's an additional requirement. It is quite clear then that there is a citizenship of the United States and a citizenship of a state which are distinct from each other and which depend upon different characteristics or circumstances. All right, now we get to the Privileges and Immunities Clause. The language is, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. And the argument that's coming is there are certain rights you have as a citizen of the United States, and those apply against the federal government. There are other rights you have as a citizen of whatever state you happen to reside in, and only those apply to the state government. In other words, even after the 14th Amendment, we're still in Barron versus Baltimore territory. It is still the case that the rights guaranteed in the Bill of Rights do not apply to the states. It is a little remarkable. Now, he's focusing on that italicized phrase, of the United States. It is a little remarkable if this clause was intended as a protection to the citizen of a state against the legislative power of his own state, that the word citizen of the state should be left out. It doesn't say states must give to everyone all the privileges and immunities that attach to being a citizen of that state. Of the privileges and immunities of the citizen of the United States, and of the privileges and immunities of the citizens of the state, it is only the former which are placed by this clause under protection of the federal Constitution. So what are the privileges and immunities of a citizen of the United States? And what are the privileges and immunities of a citizen of the state? And how have each of these been affected by the adoption of the 14th Amendment? And here he goes back to a case called Corfield versus Coryell from 1823. Opinion written by Bushrod Washington, the nephew of George. He was a Supreme Court justice who was riding circuit. In those days, Supreme Court justices would ride out and preside over district court cases in the various circuits. The issue is one of critical importance in American constitutional history. Harvesting oysters in New Jersey. Can New Jersey restrict the harvesting of oysters to New Jersey citizens. I think it was New Jersey. Was it New York? New Jersey, okay. Specifically, can they exclude people from Pennsylvania? That's who brings the lawsuit. So, under the old Article 4, remember what it means, equal treatment with respect to fundamental rights? Can New Jersey prevent someone from Pennsylvania from harvesting oysters in its waters? Oyster harvesting, to be fair, was actually a pretty major industry at that time, but nonetheless. And here's where you're going to hear the argument I described at the beginning. The answer is, no, New Jersey may not discriminate against citizens of Pennsylvania if this is a fundamental right. But actually, harvesting oysters, you may be relieved to learn, is not a fundamental right. You want an obvious analogy to this, by the way? Out-of-state tuition. Is it constitutional for Wisconsin to charge different tuition to people who are not citizens of Wisconsin or residents of Wisconsin? The answer is yes, because of Corfield versus Coriel. Because paying the in-state rate of tuition at a public university is not a fundamental right. The inquiry is, this is now Bushrod Washington talking from his 1823 opinion, which is a large chunk is just reproduced in the Slaughterhouse case opinion. The issue is, what are the privileges and immunities of citizens of the several states? We feel no hesitation in confining these expressions to those privileges and immunities which are fundamental. All right, so that's the principle, and I've explained it earlier, and now you get it. But you can see why when it goes by in one sentence, people have a hard time with it. It sort of sneaks up on you. Well, what are those fundamental rights? I'm not going to tell you. And this is about the first of about 8 times in the rest of this course, we're going to hear a Supreme Court justice say, by gosh, we have to protect fundamental rights. And what are those fundamental rights? I'm not going to tell you. Y'all know, sort of. What these fundamental principles are, it would be more tedious than difficult to enumerate. I love it. I could tell you, but you'd be bored. They may all, however, be comprehended under the following general heads. Protection by the government with the right to acquire and possess property of every kind, to pursue and obtain happiness and safety, subject, nevertheless, to such restraints as the government may prescribe for the general good of the whole. Police powers. Now, Miller is now talking in his own voice again. That was Bushrod Washington. Here's Miller's comment on that. Throughout his opinion, there's spoken of his rights belonging to the individual as a citizen of a state. They're such spoken of in the constitutional provision, which he was construing, and they've always been held to be the class of rights which the state governments were created to establish and secure. So as it says in the italicized notes, those fundamental state rights are the ones with respect to which states may not discriminate against citizens from other states under Article 4. Now, the constitutional provision alluded there, Article 4, did not create those rights, which it called privileges and immunities. It threw around them in that clause no security for the citizen of the state which they reclaimed or exercised. Nothing in Article 4 in New Jersey has to allow New Jerseyites to have any particular right, free speech, not going to prison without a trial, not having their property taken away without compensation. None of that. They didn't have to do any of that. Nor did it profess to control the power of the state governments over the rights of its own citizens. Its sole purpose was to declare to the several states that whatever those rights, right, whatever the fundamental rights, as you grant or establish them to your own citizens, the same, neither more or less, shall be the measure of the rights of citizens of other states when they are within your jurisdiction. Got it? Well, what does that have to do with the 14th Amendment? Aha, I'm glad you asked, said Miller. The 14th Amendment is the same as the Article 4 Privileges and Immunities Clause, with one change. And the change is that where before we talked about discrimination against people from other states, now we're banning discrimination based on race. So what the 14th Amendment Privileges and Immunities Clause means, according to Miller, is that the states don't have to give anybody the right of free speech. But if they do grant that right, it must apply equally to black people as well as white people. And of course, since Article 4 is still in place, it also must apply to people from out of state as well as people in state. So we're going to have 2 different axes of equal treatment that is required. And the alternative, he says, to read this any other way would imply that the 13th, 14th, and 15th Amendments had fundamentally altered the Constitution, had created a new constitutional order, and that can't be right. Was it the purpose of the 14th Amendment to transfer the security and protection of all the civil rights which we have mentioned from the states to the federal government? Where it is declared that Congress, notice that emphasis on the powers of Congress, where it was declared that Congress should have the power to enforce that article, was it intended to bring within the power of Congress the entire domain of civil rights, heretofore belonging exclusively to the states? We are convinced that no such results were intended by the Congress which proposed these amendments, nor by the legislatures of the states which ratified them. So what has changed, aside from the race issue? There is one other thing. Now, one, you can't discriminate with respect to fundamental rights. Fundamental rights only are protected. You can't discriminate on the basis of race if you're a state. And two, there's a separate set of rights that you have as a citizen of the United States. And what are these rights of Americans? They're rights that have to do with the federal government only. Like being protected from pirates, for example. It is said to be the rights of the citizen of this great country to come to the seat of government to assert any claim he may have upon that government, to transact any business he may have with it, to seek its protection, the right of free access to its seaports, through which operations of foreign commerce are conducted. Ask yourself, how many recently freed slaves had shipping companies? To the sub-treasuries, land offices, and courts of justice in the several states. Right? That was dread. Can a black person get into federal court? Yes, this says. To demand the care and protection of the federal government over his life, liberty, and property when on the high seas or in the jurisdiction of a foreign government. The right to be protected against pirates. But these all only apply to the federal government. In this case, the claim is being made that the government of Louisiana is barred by the 14th Amendment from granting monopolies, and that's just not part of the 14th Amendment. We are of the opinion that the rights claimed by these plaintiffs in error, if they have any existence, are not privileges and immunities of citizens of the United States, within the meaning of the clause of the 13th Amendment. Sorry, that's a misprint, it should say 14th Amendment. He does also discuss the 13th Amendment, but here it's the 14th. So, what's not protected? What do you not have as a right of Americans? All that stuff listed in Corfield-Coriel. The right to engage in commerce and make contracts, and the right to acquire and possess property of every kind, and so on and so on and so on. After all, says Miller, this idea that we have national rights that states have to accept would violate, I kind of feel like there's a drum roll here, state sovereignty. Whatever fluctuations may be seen in the history of public opinion on this subject during the period of our national existence, we think it will be found that this court, so far as its functions required, has always held with a steady and even hand the balance between state and federal power. And we trust that such may continue to be the history of its relation to the subject. Right, during the Civil War and the years that followed, there's a public attitude for reshaping federal-state relations, but we, the court, will be the guardians. Howard Gilman, co-author of your textbook, cites Field in another place, speaking of the court as the guardians of a constitution besieged. The guardians of our old traditional federalist order against the threats of change. And that's it. So, after all of that, at the end of the day, it seems to me, and this is obviously now just my opinion, but my opinion is that the way to understand Miller's conclusions and his reasoning is not about economics or even particularly about race relations. It's about federalism. The 14th Amendment cannot be read this broadly, because if it were read this broadly, that would give Congress sweeping powers to enact economic regulations or limit what the states can do in terms of economic regulations, as well as everything else we've been talking about. That would fundamentally alter our federalist system. But which federalist system? The one that describes states as sovereigns. This is the anti-federalist piece that he's pulling. This is the compact theory. States are sovereign entities. They were sovereign entities before the 14th Amendment, and the 14th Amendment cannot possibly have changed that. It just can't. It's just unimaginable. Field dissents. Field is Field's concern is not with black codes or race relations or the right to vote. Field's concern is economics. He is a devotee and a devotee of, if not quite laissez-faire economics, he wants the adoption of the 14th Amendment to be a transformative moment that prevents class legislation from going forward. Remember, he loses this argument, but this argument that he makes is going to become tremendously influential going forward. So let's take a look at it. And first of all, he says, look, it's all very well to talk about police powers, but if something's a right, the whole point of saying that is that it trumps police powers. That's pretty much what we mean by the word right, isn't it? Under the pretense of prescribing a police regulation, the state cannot be permitted to encroach upon any of the just rights of the citizen which the Constitution intended to secure against abridgment. This is tautology, he's saying. Yes, of course there are police powers, but saying that doesn't tell you anything. Because the question is still whether is the state infringing on a right. And if the state's infringing on a right, then that's not a legitimate exercise of police powers. This is a tautological, definitional kind of argument. Granting corporate monopolies, says Field, is not an example of police powers in action. It's class legislation. In the law in question, there are only two provisions which can properly be called police regulations. The one which requires the landing and slaughtering of animals below the city of New Orleans, the other which requires inspections. In other words, parts of this law are about health and safety. Right, below the city of New Orleans, so that blood and offal will not get into the waterways that flow through the city, the Mississippi River. Right? Those are police powers. But the rest of it, he says, in all other particulars, the act is a mere grant to a corporation, created by it of special and exclusive privileges by which the health of the city is in no way promoted. A radical new idea. States have police powers. That hasn't changed. But if a state acts outside its police powers, it's violating the Constitution. Field's argument is that the 14th Amendment limits states to exercise of traditional police powers. It precludes states from experimenting by regulating in new areas like the economy. Because doing that infringes on these rights of Americans that we didn't have before, but we do now because of the 14th Amendment. What about the analogies to bridges and turnpikes and common carriers? It's a false analogy, he says. Of course we've always had common carriers. Right? Field is perfectly happy with anything we've always had. It's the new that bothers him. These new corporations, things. Of course we've always had common carriers, but those were different, he says. Those were for a public purpose. They weren't business corporations for the profit of shareholders. They were to carry out a governmental task of some kind. It is sought to justify the act in question on the same principle that exclusive grants for ferries, bridges, and turnpikes are sanctioned. But it can find no support there. Those grants are a franchise of a public character appertaining to the government. What do you get when you drive outside of Madison? You get into unincorporated Wisconsin. The old understanding of corporation was something of the government. Their use usually requires the exercise of a sovereign right of eminent domain. It is for the government to determine when one shall be granted on conditions on which it shall be enjoyed. The grant with exclusive privileges of a right appertaining to the government is a very different thing than a grant with exclusive privileges of a right to pursue one of the ordinary trades or callings of life. Right? You're not pursuing a government project here, building a dam, running a ferry. You're not carrying out a public function. You're using the powers of government to benefit one set of economic actors over another set of economic actors. In other words, class legislation, which now is unconstitutional because that is not police powers. That's something else. That's the end of his background discussion before he digs into the 14th Amendment. And as I said, he also had a long discussion of English common law. It's kind of fun to read because Miller says if you read English common law, it's absolutely clear that monopolies were widely accepted and widely used all the time. And Field says if you read English history, it's absolutely clear that monopolies were completely detested and utterly not allowed. It's completely different conclusions from looking at essentially the same set of sources. But having set all this up in the same way that Miller set it up by defining what police powers are. Field has set up his discussion by defining what they are not. And now we turn to the question of what does the 14th Amendment have to say about all this? And he, like Miller, agrees this is the most important question ever. The question presented is therefore one of the gravest importance, not merely to the parties here, but to the whole country. It is nothing less than the question whether the recent amendments to the federal Constitution protect the citizens of the United States against the deprivation of their common rights by state legislation. Does the phrase privileges and immunities of citizens of the United States mean we have rights as Americans that states may not infringe upon? Miller said no. Field says yes. 14th Amendment. Again, we begin with Dred Scott because unquestionably the very first thing that the 14th Amendment does is overrule Dred Scott. The first clause of the 14th Amendment changes this whole subject. It recognizes in express terms, if it did not create, citizens of the United States. A citizen of a state is now only a citizen of the United States residing in that state. He's rejecting dual citizenship. No, he says. He's going all the way back to Story and Marshall, right, and Wilson and Chase and the early High Federalists. We're part of a national people. We are citizens of a nation. To be a citizen is to have rights. We have national rights, and where we reside in a state is a coincidence. It's a secondary thing. What Lincoln said, the Union created the states. It is older, remember? This is a fundamental division. And right here in 1873, the same fundamental division we saw in the 1780s is still being fought out. It's the Miller's version of the compact theory versus Field's national theory. A citizen of a state, the fundamental rights, privileges, and immunities which belong to him as a free man and a free citizen now belong to him as a citizen of the United States and are not dependent on his citizenship of any states. So Field says we have a new category. Back in Corfield versus Coryell, we had fundamental rights of state citizenship. Now, we have fundamental rights of national citizenship. And whatever those are, states are obliged to respect them for everyone. This shouldn't sound strange. This is how we think about it today. Well, it should sound strange that this was the losing argument. The losing argument was that the Constitution guarantees rights that apply to states in 1873. I'll give you another spoiler alert. It will not be until the 1920s that a court will say that any rights guaranteed in the Constitution limit the actions of states. Back to Field. Now, he's not claiming that the Privileges and Immunities Clause invents new rights. It merely insists that the ones that we already know about be respected. The amendment does not attempt to confer any new privileges or immunities upon citizens or to enumerate or define those already existing. It assumes that there are such privileges and immunities which belong of right to citizens as such, and ordains that they shall not be abridged by state legislation. After all, he says, if it didn't mean that, it wouldn't do anything. It would just be Article 4. It is, if this inhibition has no reference to privileges and immunities of this character, but only refers to privileges and immunities as were before its adoption designated in the Constitution, that is Article 4, it was a vain and idle enactment, which accomplished nothing. If Congress's power, or the court's power for that matter, is not to compel states to recognize any particular rights at all, then we didn't do anything. This whole war that we just had, we didn't do anything. It's all the same. Well, what are these fundamental rights of citizens? He's not going to tell you. What then are the privileges and immunities which are secured against abridgment by state legislation? And here he does something really interesting. This is a move we'll see again. I'm not sure we'll see it in our course readings. It shows up again. He says, go back to the Civil Rights Act of 1866. That first sweeping piece of congressional legislation adopted even before the 14th Amendment was adopted. That tells you what the national rights are. And if you want to know what the 14th Amendment is about, it's about saying states can't violate any of the sorts of things covered by the Civil Rights Act of 1866. In the first section of the Civil Rights Act, Congress has given its interpretation to these terms, or at least has stated some of the rights which in its judgment these terms include. It has declared they include the right to make and enforce contracts, to sue, be parties and give evidence, to inherit, purchase, lease, sell, hold, and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property. In other words, 42 U.S.C. 1981 and 42 U.S.C. 1982. What about Corfield versus Coryell in Article 4? What about Miller's argument that we ought to read the 14th Amendment the same way we read Article 4, that nothing has changed? Or nothing much has changed, except for adding race as a category. What the clause in question, 14th Amendment, did for the protection, what the clause in question, referring to Article 4, did for the protection of the citizens of one state against hostile and discriminating legislation of other states the 14th Amendment does for the protection of every citizen of the United States against hostile and discriminating legislation against him in favor of others, whether they reside in the same or in different states. The privileges and immunities of the citizens of the United States, of every one of them, is secured against abridgment in any form by the state. The 14th Amendment places them under the guardianship of the national authority. So this is the broad reading of 14.5. The 14th Amendment means there are rights that states are obliged to observe, and 14.5 gives Congress the authority to pass appropriate legislation to enforce those rights. And if you want to know what they look like, check out the Civil Rights Act of 1866 as a partial list of the liberties which Congress is empowered to protect. And then, all monopolies in any known trade or manufacture are an invasion of those privileges. Class legislation. What's one of those fundamental rights? Not mentioned in the Civil Rights Act of 1866. Right? We're going to go beyond that. Civil Rights Act of 1866 is about racial discrimination. Yeah, but the very same principle, says Field, means you can't have class legislation. You can't have corporate monopolies. You can't have private corporations with special privileges. All monopolies in any known trade or manufacture are an invasion of those privileges, for they encroach upon the liberty of citizens to acquire property and pursue happiness, and were held void at common law in the great case of monopolies decided during the reign of Queen Elizabeth. That's back to that debate. They go back and forth, the two of them, as to how we ought to understand Queen Elizabeth. So what are the rights of U.S. citizens? This equality of right with exemption from all disparaging and partial enactments in the lawful pursuits of life throughout the whole country is the distinguishing privileges of citizens of the United States. These are the rights of Americans. The rights we have because we are Americans. To them everywhere, all pursuits, all professions, all avocations are open without other restrictions than such as are imposed equally upon all others of the same age, sex, and condition. It's kind of an equal protection principle, even though there's not a name for that yet. There's an equal protection clause in the 14th Amendment, but there hasn't yet started to be a discussion about what it means. But this idea of being similarly situated. You can never treat people differently without a good reason, which includes giving one business actor an advantage over another. What would be a good reason? Police powers. And you can now see how the logic pulls together. Right? You can never treat people differently without a good reason. What's the limit of a good reason? Police powers. What does that mean? You have a right as an American not to have states pass any law that limit your activities outside of police powers. Yes? Nope. Sort of, yes, maybe, we'll see. Short answer, sort of. It's sort of like asking what's your relationship to your great-grandparents. There is one, of course. There's a connection, and we can draw a line, but it's not as though we learn a whole lot about you from studying them. So back to the idea of state, and this comes very close, this theory, to describing states as having enumerated powers in the same way the federal government does. Think about the logic here. States retain their traditional police powers. It is the right of every American not to be subjected to exercises of state authority outside the police powers. Why? Because outside the police powers, outside the traditional limitations that we all accept, right? And all understand and are very traditional. Notice we don't list either. We don't list the police powers, we don't list the fundamental rights. They're both just sort of, yeah, you all know what I'm talking about. A lot of hand-waving going on when it comes down to specifics. But if the state is acting outside police powers, it's infringing on your liberty. And Americans, qua Americans, have a right not to have their liberties infringed upon by the states, just as they have the right not to have their liberties infringed upon by the federal government. Does this mean the Bill of Rights? Probably, at a minimum. I mean, he cites the Civil Rights Act of 1866, which goes much further. Remember, the Civil Rights Act of 1866 said you can't deny people the opportunity to engage in economic activity based on their race. No, says Field, it's much further than that. You cannot deny people the opportunity to engage in economic activity, period, unless doing so is an exercise of police powers. So the health and safety regulations, those were fine. The monopoly part was not. All right. The state may prescribe such regulations for every pursuit and calling of life as will promote the public health, secure the good order, advocate the general prosperity of society, but when once prescribed, the pursuit or calling must be free to be followed by every citizen who is within the conditions designated and will conform to the regulations. In other words, there's this circularity here. You have a right to engage in all lawful business pursuits. That becomes circular if you say, well, it's not lawful if the state outlaws it. But what it means is you have a right to engage in all economic activities permitted by general laws in the exercise of police powers. Any more specific law, more specifically targeted law that intervenes or interferes with the opportunity to pursue your economic activities is outside the scope of police powers and a violation of rights. And that's it. Now, Field lost that case. That was a great question. I'm sorry if I sounded all dismissive. I didn't mean to be. I sort of choked because the answer is complicated. It is absolutely the case that Field establishes the blueprint, the intellectual blueprint for thinking about the 14th Amendment as a transformative change in federalism and a transformative change in the scope of rights that people can assert, both in courts and as rights within the purview of 14.5 authority of Congress. That's absolutely true. But he loses the argument in the case, so at least right away, what we're told is the 14th Amendment doesn't mean any particular rights are secured, only a kind of equal treatment provision. Well, guess what happens with that ruling? So Miller wrote the 5-4 opinion that said, no, the Privileges and Immunities Clause of the 14th Amendment doesn't secure widespread economic liberties. And in the years following, this was immediately turned around to say, aha, that means it doesn't secure racial equality either. United States versus Reese, 1876. Remember how the 15th Amendment says you can't deny people the right to vote based on their race? Yeah, says the Supreme Court by a vote of 7-2, but that doesn't mean states have to actually count those votes. The 15th Amendment does not confer the right of suffrage upon anyone. Well, the specific. Election inspectors refused to accept the ballot submitted from black voters. They were charged under one of the Klan Acts. The charge was dismissed. The court ruled the Klan Act was not appropriate legislation because the remedy was not limited to interfering with voting on the basis of race. That is, the Klan Act said a conspiracy to prevent people from voting is a crime. No no's of the Supreme Court. The 15th Amendment only gives Congress the power to prevent interfering with voting on the basis of race. It does not mean that states have to give anyone the right to vote in particular. Think Slaughterhouse. States aren't required to let anybody vote in particular, but if they allow people to vote in a certain way, that has to be permitted without racial discrimination. That's all. The 15th Amendment does not confer the right of suffrage voting upon anyone. It prevents the states from giving preference to one citizen of the United States over another on account of race, color, or previous condition of servitude. Before its adoption, this could be done. Before the 15th Amendment, they could do that. The right is exemption from discrimination. This, under the express provision of the second section of the amendment, Congress may enforce by appropriate legislation. Right? Congress can prevent racial discrimination in voting. That doesn't give Congress any power to ensure people actually have a right to vote, period. You can set the requirements for voting as only someone with more than $1 million worth of real estate in our state may vote, and that's fine. As long as you don't say only white people with more than $1 million in real estate, etc. Minor versus Hopperset. Wait a minute, privileges and immunities in the United States, equal protection, women. I bet this means women can vote. Nah, no it doesn't. A unanimous court this time. The Constitution does not define the privileges and immunities of citizens. For that definition, we must look elsewhere. In this case, we need not determine what they are, again, but only whether suffrage is necessarily one of them. It certainly is nowhere made so in express terms. The United States has no voters in the states of its own creation. The elective officers of the United States are all elected, directly or indirectly, by state voters. Right? Article 2, the states determine who is eligible to vote in national elections. The amendment did not add to the privileges and immunities of a citizen. This is straight Slaughterhouse, straight Miller. It simply furnished an additional guarantee for the protection of such as he already had. Remember, this is the dual citizenship theory. 14th Amendment didn't mean states have to grant you any more rights. It just changed the way they could deal with those rights. It's an equal treatment principle, just like Article 4 in Corfield versus Coriell. No new voters were necessarily made by it. Indirectly, it may have had the effect. It may have increased the number of citizens entitled to suffrage, but it operates for this purpose through the states and state laws, and not directly upon the citizen. You have no 14th Amendment claim against your state for preventing you from voting, only for, if it were to occur, states preventing you from voting on the basis of your race. And then comes Cruikshank. And I do have some time, which is good, although I'll try not to use all of it. So go back to last time. That timeline we went through, and the series of, first under President Johnson, the southern states held whites-only conventions and adopted new constitutions, right? Then came congressional reconstruction, and now black people were permitted to vote and hold office, and there were a series of contested elections. In that period, by the way, black turnout was higher than it would be until any time again until the 1970s. By contrast, when you get to the 1900s, black voting in Mississippi is like 2%. Just an idea just how limited things were. So, but we're in that period in which, due to the imposition of martial law, due to the fact that southern states weren't allowed to rejoin the Union until they had ratified the 14th Amendment. I don't know how many of you knew that story. The adoption of the 14th Amendment is a great story in arguably illegitimate constitution making. Due to all that stuff, we had elections in which Republicans, and specifically black Republicans, were elected to office in areas across the South, which resulted in violent responses from white residents. I mentioned Wilmington, Delaware. This is Colfax. So in Louisiana, the white Democratic candidates declared that the election had been stolen. They said it's a fake election. It was stolen from us. We don't recognize it. Therefore, we're the actual elected officials. President Grant sent in federal troops to restore order, and in Grant Parish, a group of black men took over Grant County Courthouse. They took it over because they had heard there was a white mob coming to throw out all the elected Republican officials. So they took it over to protect it against this threat. The problem was, when I say that this was a white mob, I'm kind of understating a little bit. They had cannons. They had artillery. This is an organized group. We are not talking about a bunch of angry farmers. They surrounded the courthouse. Eventually, people inside surrendered, and they were all killed. At least 100 unarmed, having already surrendered, black people were massacred. Allegedly, 3 white people were killed in the process as well, probably by crossfire. It's not clear there was any firing coming from inside the courthouse, although there might have been, we don't know. Federal prosecutors secured convictions under the Klan Acts on 16 separate counts. The whole thing is really complicated and long, and I'm not going to walk through each of the charges and each reason why each one was thrown out by the U.S. Supreme Court. But each one was thrown out by the U.S. Supreme Court fundamentally because of Slaughterhouse. No matter what happened here, there was no violation of federal rights, like being protected against pirates. These are state rights. And if you feel like your state rights have been violated, what should you do? Go to your state legislatures. Louisiana will protect its black citizens against the possibility of being attacked with cannons. For example, and we start with, studying Slaughterhouse, dual citizenship. We have in our political system a government of the United States and a government of each of the several states. Each one of these governments is distinct from the others. Each has citizens of its own who owe it allegiance and whose rights within its jurisdiction it must protect. The same person may be at the same time a citizen of the United States and a citizen of a state, but his rights of citizenship will be different from those he has under the other, than one from under the other. Cite Slaughterhouse. All right, start with basic principles. Dual citizenship, there are state rights and there are federal rights. If you want a federal remedy, if Congress wants, with this Klan Act that it has passed, Anti-Klan Act, there are 3 Anti-Klan Acts. If Congress wants to protect the right, it can only be a federal right. Congress has no authority to protect state citizens, apostrophe, states' rights. That was horrible. Congress has no authority to protect state rights, state-level rights. It can only ensure non-discrimination, that equal treatment principle, like Corfield versus Coriell in 1823. Congress can only enforce non-discrimination in the way those rights are protected or not. No rights can be acquired under the Constitution or laws of the United States except such as the government of the United States has the authority to grant or secure. The target is 14.5, limiting Congress's authority. All that cannot be so granted and secured are left under the protection of the states. Back to Miller's opinion. If it isn't one of those federal rights, the right to go to federal court, the right to get a passport, the right to be protected from pirates, the right to use seaports to engage in commerce, if it isn't one of those federal rights, then it's none of the federal government's business. And now we go through the various claimed rights that were asserted. And the survivors of these dead people claimed that the state had violated numerous of their rights. The right to freedom of assembly and petition, the right of free expression, the right to have arms. This is an early gun case, actually, of all odd things. And the right to vote. But none of those apply to the states. The First Amendment to the Constitution prohibits Congress from abridging the right of the people to assemble and to petition the government for a redress of grievances. This, like other amendments proposed and adopted, was not intended to limit the powers of the state governments. In 1787, unquestionably true. The particular amendment now under consideration, that's the 14th Amendment. I'm sorry for these footnotes, but it can get confusing. I hope this is helpful rather than irritating. And so first he was talking about the First Amendment as of 1787. Now we're asking what, if anything, did the 14th Amendment do to alter our understanding of that provision. The particular amendment now under consideration assumes the existence of the right of the people to assemble for lawful purposes and protects it against encroachment by Congress. The right was not created by the amendment. Neither was its continuance guaranteed except as against congressional interference. For their protection and its enjoyment, therefore, the people must look to the states. The power for that purpose was originally placed in them and has never been surrendered to the United States. It's a police powers issue. And if the states don't choose to protect rights of assembly, great. Same for guns. The 2nd and 10th counts of the indictment are equally defective. The right there is specified that of bearing arms for a lawful purpose. This is not a right guaranteed by the Constitution. Neither is in any manner dependent on that instrument for its existence. The Second Amendment declares that it shall not be infringed. This, as we have seen, means no more that it shall not be infringed by Congress. You don't have to have a right to bear guns. People can have them or not have them. Notice in a conflict between, this is 1876, right? So it's 10 years after the end of the war. In a conflict between Confederate veterans in highly organized forces and 10 years ago freed slaves, the level of armament is like, they had cannons. I'm sorry I keep coming back to that, but can you imagine, artillery? Really? And there is no 14th Amendment right to be free from interference in voting. After all, we just said that in Minor versus Hopperset, talking about women. In Minor versus Hopperset, we decided the Constitution of the United States has not conferred the right of suffrage upon anyone. And the United States have no voters of their own creation in the states. Inasmuch, therefore, as it does not appear in these counts, the intent of the defendants was to prevent these parties from exercising the right to vote on account of their race, it's no good. What was that about? Wait, one more sentence before I tell you. We may suspect that race was the cause of the hostility. You think? But it was not so averred. Something very curious happened here. And I have consulted with historians who work in this area. I'm giving you the best answer I've been able to get. The prosecutors wanted to use this case to establish a general right of access to the ballot box. So when they wrote the indictments, despite the obvious context of these events, they described it as a violation of the Klan Acts to interfere with people in the act of voting. The court says, aha, you didn't specifically allege this was interference with voting on the basis of race. And I know I keep saying this to the point where it's probably boring, but there is no, here is an affirmation, there is no right to vote. There's only a right not to be discriminated against in voting on the basis of race. And now that you've read Slaughterhouse, you understand what that means. That's one of the 1,000 reasons this case is so important. All right, one more piece. Ruffin versus Commonwealth. We talked about the black codes. We talked about Jim Crow a little. We mentioned it. I mentioned that it's coming. I haven't mentioned the prison industrial complex, as it came to be known. One of the mechanisms for restoring social order in the South after the after this war, was a passage after the Black Codes were struck down. Was a passage of a whole new set of laws that, on their face, looked racially neutral, notably anti-vagrancy laws. You'd be put in jail if you didn't have a job or didn't have any money. This was used to imprison hundreds of thousands of almost exclusively black men for a period of generations. They were then put to work without being paid. They were slaves. At one time, the largest manufacturing plant in Texas was a prison textile firm. That was around 1890. So this was not a trivial element of the Southern economy. This was a piece of rebuilding the white-dominated economy. Did that have any constitutional problems? Remember what I said earlier. I made the assertion that the problem with talking about national rights in the context of slavery is that slavery violates all rights simultaneously. Why doesn't this? This is not the U.S. Supreme Court. This is the Supreme Court of Virginia in 1871. The answer is, remember where the 13th Amendment says no one can be enslaved except as punishment for a crime? If you're in prison, you're a slave. The Bill of Rights is a declaration. The specific issue had to do with, under the Virginia Constitution, there was a right to trial by jury in, quote, your vicinage, meaning locally. Jury of your peers meant people from the same town you were from or same area you were from. Problem was, this guy was a prisoner. He'd been transported to a prison far away from where he was originally from. He committed a crime as a prisoner and trying to escape and was sentenced to death. The question, did he have a constitutional right to a jury from his hometown under this Virginia provision? What's more important, as always, is not the specific issue, but the statement that's going to emerge right now, that once you're imprisoned, you have no rights. The Bill of Rights is a declaration of general principle to govern a society of freemen, and not of convicted felons and men civilly dead. Such men have some rights, it is true, such as the law in its benignity accords to them. The law in its benignity, right? States may choose to give prisoners certain rights. Remember Dred Scott? States may have chosen to give black persons certain rights, but they weren't entitled to them. But not the rights of freemen. They are the slaves of the state, undergoing punishment for heinous crimes. While in this state of penal servitude, they must be subject to the regulations of the institutions of which they are inmates, and the law of states to whom their service is due in the expiation of their crimes. They are the slaves of the state. Not only practical or metaphorical equivalents to slavery were back within 10 years, slavery was back within 10 years. In this carefully defined and legalized form, of course. And we will leave it there. That's Slaughterhouse and the aftermath of Slaughterhouse. I'm afraid the depressing part isn't over yet. In our next lecture, we will hear how the Supreme Court found a way to strike down the Civil Rights Act of 1875 as being beyond Congress's 14-5 powers as well.